Article 1 common to the four Geneva Conventions reads as follows: the high contracting parties undertake to respect and to ensure respect for the present convention in all circumstances. This provision was reiterated in Article 1, paragraph 4, of Additional Protocol I. As such, the obligation to respect and ensure respect, which will also be referred to as Common Article 1, applies to international conflicts and, indeed, to non-international conflicts to the extent that the latter are covered by Common Article 3. While conflicts of a non-international character, as defined by Additional Protocol 2, are not explicitly covered by the obligation to respect and to ensure respect, they can nonetheless be considered as indirectly falling within the purview of the provision, insofar as Protocol 2 is merely an elaboration of Common Article 3 of the four Geneva Conventions, a fact stated in its Article 1, paragraph 1. The obligation to respect and to ensure respect for humanitarian law is a two-sided obligation, for it calls on states both to respect and to ensure respect the conventions. To respect means that the state is under an obligation to do everything it can to ensure that the rules in question are respected by its organs as well as by all others under its jurisdiction. To ensure respect means that states, whether engaged in a conflict or not, must take all possible steps to ensure that the rules are respected by all, and in particular by parties to conflict. Some argue that such an interpretation was not the one originally envisaged by the drafters. They hold that Article 1 was not elaborated with the intention of imposing on states obligations, which did not also derive from the other provisions of the Geneva Conventions. While this may be the case, an examination of the Travaux Preparatoires reveals that the negotiators at least bore in mind the need for the parties to the conventions to do everything they could to ensure universal compliance with the humanitarian principles underlying the conventions. This is nonetheless a minor consideration, since the historical interpretation of an international instrument can never prove decisive in identifying the current status of a legal norm. Far more relevant in this respect is the meaning conferred by international practice as it has developed since the instrument was adopted. Indeed, over the last half-century the practice of states and international organizations, buttressed by jurisprudential findings and doctrinal opinions, clearly supports the interpretation of Common Article 1 as a rule that compels all states, whether or not parties to a conflict, not only to take active part in ensuring compliance with rules of international humanitarian law by all concerned, but also to react against violations of that law. Moreover, Common Article 1 speaks of an obligation to respect and to ensure respect in all circumstances, making the obligation unconditional and, in particular, not subject to the constraint of reciprocity. It is now widely accepted that the obligation contained in Common Article 1 is binding on all states and competent international organizations. In its recent advisory opinion on the legality of the threat or use of nuclear weapons, the International Court of Justice reinforced this assertion, noting that a great many rules of humanitarian law applicable in armed conflict are so fundamental that these fundamental rules are to be observed by all states whether or not they have ratified the conventions that contain them. The same court, in its earlier decision on merits in the landmark Nicaragua case, had specifically demonstrated the fact that the obligation referred to in Common Article 1 forms part of customary international law. In diplomatic circles, Common Article 1 has come to be seen by many as implying a universal obligation for states and international organizations, be they regional or universal, to ensure that this body of law is implemented wherever a humanitarian problem arises. The issue of implementation of international humanitarian law has thus become a more central feature in the activities of states and international organizations. Having set out the scope and content ascribed to Common Article 1, attention will now focus on the various dimensions this provision has acquired over the years. First of all, it is necessary to ascertain, on the basis of contemporary practice, what precise obligations are attached to the obligation to respect international humanitarian law in all circumstances. Emphasis will then be placed on the corresponding obligation to ensure respect.